When a criminal defendant testifies at trial and tells a different story from that of the prosecution's witnesses, a common prosecution tactic is to ask why the defendant didn't tell his story to the police earlier. But what if police have advised that the defendant has a right to remain silent? Can the prosecution then use the defendant's silence against him? The United States Supreme Court considered that question in the 1976 case of Doyle v. Ohio. Jefferson, Doyle, and Richard Wood, who we'll call the defendants, were charged with selling marijuana to William Bonnell, a police informant who was trying to earn a break on his own charges. Bonnell testified that he arranged to buy marijuana from the defendants. The marijuana exchange took place in a parking lot where supervising officers couldn't see the actual transaction. They could only see Bonnell holding the drug package. After Bonnell drove away, officers stopped the defendant's car, found the drug money, arrested them, and advised them of their Miranda rights. At separate trials, Doyle and Woods claimed that Bonnell intended to sell the drugs to Doyle. They claimed the sale fell through, Bonnell grew angry, threw the drug money into Doyle's car, and left with the marijuana. Because the officers hadn't actually seen the transaction, the defendant's story was plausible. On cross-examination, the prosecutor asked whether either defendant told this story to officers after they were arrested. The trial court overruled the defendant's objections, and both testified that they didn't tell this story to officers. Both defendants were convicted. The Court of Appeals affirmed both convictions, and the Supreme Court of Ohio declined to review the cases. The United States Supreme Court granted the defendants cert petitions.